You have analyzed the case technically, and you have prepared mentally to present your opinions during a trial. If you have never testified in court, you could be uncertain about how the entire process works. In most cases, the attorneys know in advance roughly how many days or weeks have been allotted to the entire case by the judge. In the beginning of each case, the attorney for the plaintiff will present his case. Following the plaintiff's presentation of his case, the defendant's attorney will present the case for the defense. There may be eyewitnesses, and there may be other fact witnesses called to testify. At some point during each of these two halves of the case, the experts will be called to present their findings and opinions. If the plaintiff hires you, then you will testify during the first half of the trial. If the defense hires you, then you will testify during the second half. Regardless of when you precisely begin your testimony, your retaining attorney will ask you questions first. This first presentation of fact and findings by you is called the direct examination. During direct examination, your attorney asks questions to make your findings known to the court. After you have had this direct opportunity to present the relevant data and opinions that you have to offer, then the other side's attorney has an opportunity to begin his questioning. This questioning by the opposing counsel is called the cross-examination, and it is a dangerous phase of the trial testimony for you as an expert witness. It will be the entire subject of the final Lesson 12. Answering questions under the bright lights at a trial is the ultimate for an expert witness. It represents the culmination of your work and everybody else's work. Money, reputation, sometimes even lives are at stake. The ability to testify successfully at trial is so important that Lesson 11 focuses solely on how to do that. You may spend months or years preparing materials, meeting people, having conversations, performing analyses, and writing reports. It leads to this moment. The direct examination by your attorney is largely stress-free because you should know in advance roughly what your attorney will ask and what you intend to say. The questioning by the opposing counsel, however, is the hardest part and dangerous to the reputation and ultimate value of an expert witness. Lesson 12 focuses solely on performing well during cross-examination.